I am a European and UK patent attorney at Withers and Rogers. We are a firm of patent and trademark attorneys. My speciality is in software patents. Really pleased to be able to join you guys today and be able to discuss a little bit about the UP and the Unitary Patent Court, which are quite interesting developments.
Thank you. And with that said, before launching directly into kind of the impending system that is going to come into effect, we thought it would be a little beneficial, especially since there might be some law students online, to give you a bit of background about the current system and even some of the reasoning behind filing a patent with the EPO in general. So why someone would want to file with the EPO? So the overwhelming majority of companies tend to want to become the global powerhouses, multinational companies. And for that aspect, you would have to protect your intellectual property in various jurisdictions because patent rights are territorial. And often there are some decision making that goes into that process of where you want to file another patent application in a jurisdiction outside of your own, and those can entail where your manufacturing is, where your research and development is, where you generate revenue. Also, for all of those issues, where those issues can be turned on to where your competitors do those same things. So here is an illustration of the GDP for the world and who's leading. And as you can see, the U.S., which is a very popular jurisdiction, is in second. The European Union is third, behind China and the U.S. But while China is number one, at least in this slide in 2020, there are a bit of reason why you might prefer the EU as opposed to China with regard to just the ability to do business in China, as well as the effect of your ability to enforce patents, which has become better of recent, but there's still probably more stability with the European Union. Next slide, please. So here are the member states currently of the European Union, or the EPO. And originally, the EPO was founded in 1973 with 16 signatory states. This single EPO patent allows you to go through a single patent process from submitting a patent application through examination and grant, and then allows you the ability to validate in any of these member states that are members of the EPO. Next slide, please. And as I mentioned, this is the current process at the European Patent Office. So here you file a European patent application. It'll go through the formalities at the EPO. The examiner will conduct a search and provide a preliminary report on patentability, so their assessment of your application in view of what they found in the art and some of the other aspects that rules and articles in line with the EPO regs. And then you'd proceed to substantive examination, where you'd have a full-on process like you normally do at the USPTO. And hopefully on the back end, you'll be able to successfully prosecute your application to grant and receive a 71.3 communication, basically indicating that you've met all of the requirements of the EPO to be awarded a patent application. And then from there, you notify the EPO where you'd like to validate your patents. And so that entails a submission. So you get the grant and you say, I would like to validate or basically have a patent in country A, country B, country D, country C. So normally pre-Brexit, the overwhelming majority would be, I want to validate in the UK, France, and Germany, because that's where the majority of revenue was in the EP. And from there, you'd be granted a national, you'd get a UK patent, you'd get a French patent, and a German patent. And at that process, then you'd have to pay yearly renewal fees to maintain those patents in those countries. Next slide, please. So this is just to give you a sense of how the unitary patent and patent court started and kind of where we are now. So it actually, these talks have been going on for decades. The first discussion started in 2009 to basically lay out some of the details for the unitary patent and the unitary patent court. In 2012, the European Council and Parliament allowed or approved the unitary patent system. As soon as the approval came, then there were challenges from certain countries that were not in favor of this new system, like Spain. There were several court decisions, and which were subsequently dismissed in some aspect for Spain. There were also court challenges from Germany as well. But the big wrench in the system grinding to a halt essentially was Brexit. So in 2016 was Brexit, when the UK voted to leave the EU. And because the UK was one of the central locations for the unitary patent courts, so they were primarily going to handle life sciences and have certain courts. This kind of left a lot of uncertainty and kind of put the brakes on things and slowed things down, as well as it kind of reversed some of the requirements of having the requisite number of ratifications to move forward with the system in general. So that slowed things down, and then the UK officially left the EU, and so they had to have additional talks. And Germany in 2021 filed, there was another challenge, which was recently dealt with. And the final hurdle was just 2 months ago, January. Austria became the last state necessary for ratification and to have the system move forward, subsequent to certain approvals to launch that are necessary by German approval process. So hopefully from that time frame that Germany finally gives their approval and process, then the UPC will come into effect sometime this fall.
No, thank you, Devon. It's this has been a very, very long journey, as I'm sure you'll have seen. It was quite interesting as well to see in the previous talk we've been, there was a discussion of the potential of new IP rights coming into existence in the metaverse, and here we have some actual new IP rights coming into existence in Europe. So it's quite a change for us, and it's hopefully what I'll aim to do over the next 20-30 minutes or so is give a little bit of background on the courts themselves, the structure, what it means for people who will be dealing with the unitary patent. As I mentioned before, it's a creation of essentially of a new set of rights which are coming into existence. But the main thing as well is there's a lot of strategic concerns which will come in, which are going to need to be considered as part of the unitary patent. I was just speaking to Brianna, who's managed to join us, talking about how actually the speed of the unitary patent court, which is one of the main selling points of it, might actually come into play on the kind of the worldwide litigations as well. So, right, so just a brief overview then of this is, as I appreciate, quite a few of you have got varying knowledge of what is the unitary patent and the unitary patent court. So during the course of this, I'll refer to the UP as the unitary patent, the UPC as the unitary patent court, just for brevity. But I'm just going to start with a bit of an introduction as to why it's relevant and what it is essentially as well. So as Devon summarised for us beforehand, the current situation in Europe is that we have there's a central granting authority, which is the European Patent Office. And once a European patent has been granted, it then gets divided up into a series of national rights. And each of those rights, being national rights, are litigated and treated separately. So obviously, a positive injunction in Germany wouldn't necessarily mean the same in France, for example. But as we'll see, what's happening now is this may well change. Well, this will change actually under the unitary patent. And so there are two things which are going to happen. There's one which is the unitary patent, and then there's a new forum in which to litigate unitary patents and existing European patents as well. So this point about the new forum is quite an important one, especially for people who are portfolio holders, because if you allow nothing to happen, as I'll explain in a bit of detail later on, you'll end up with your patents potentially being litigated in this new forum without you really realizing it. So it's obviously of interest and for a lot of people to kind of get on board with this and get up to speed with it pretty quickly. So the main thing here is that whereas before we were talking about having a series of national or individual rights, individual patent rights resulting of the grant of a European patent, what the unitary patent is essentially, as it says, it's a patent which has a unitary effect across all member states. So there will be one single renewal fee. So unlike, as Devon showed beforehand, each country would have its individual renewal fees for all countries which are deemed to take effect in the unitary patent. That there'll be one single renewal fee for all of those. The main thing is that the unitary patent will, because it has unitary effect, you won't be able to sell off, as you may do at the moment. You won't be able to sell off in individual countries or split the rights off in individual countries. You're able to assign them, but the patent right has to remain unitary, it has to remain as a whole. The other things to note, as we said here, is that it is a European Union initiative. So the European Patent Office is separate from the European Union, and there are plenty of member states, including the UK, Switzerland, Norway being the main ones, and Turkey, who aren't part of the European Union, but who are part of the EPO. And so it's only countries which are in the European Union which will be able to join, which will be covered by the unitary patent. And the same is true with the new court which accompanies, which is the Unitary Patent Court, which is going to be the new forum going forward for the litigation of all unitary patents. And as we'll see in kind of the next decade or so, will also be the forum for litigation of any patent granted by the European Patent Office. So presently, you're able to litigate in national courts, but that in the next decade or so, that will no longer be the case there. So the key feature really of the unitary patent in the court is that the judgments as well, which is provided by the unitary patent court for unitary patents, will be applicable to all member states. So for example, if you had a finding of infringement of a unitary patent in a unitary patent court, then that finding of infringement will apply to all 17 member states at the moment. The flip side of that as well is that damages will be scaled accordingly. So instead of having damages based on one territory, you're having damages based on essentially pretty much all of the European Union. So given the size and population of it, that then becomes quite a substantially larger, potentially a larger amount. But the main advantage of this is that it obviously removes the need to litigate your patent in multiple jurisdictions. You'll be able to litigate at a single point at this European, at the UPC or the Unified Patent Court, and then that judgment will automatically cover all the territories, so the potential for litigation costs goes down. But there is obviously some kind of flip side to this. It's not all upside, unfortunately, is that your patents now, if they are in the unitary patent, will now have a single point of attack. So if your patent is revoked in one territory under the unitary patent, it's revoked everywhere. So if you have certain, for example, pharmaceutical clients have been quite worried about this prospect, and that the idea that you may lose your blockbuster pharma patent from one single point of attack. So, but at the same time, again, if you're litigating, then the damages would be scaled accordingly. So there's a balancing act to be had there. So let's just go quickly through the system. So as I said there, the unitary patent covers all the member states. The member states are shown there on the left, and put them in blue as well. Of the main countries which we can see for the moment out of Europe, which aren't included, the main ones being Spain and Poland, in terms of one population and GDP. Now, Spain and Poland have said that they're very unlikely to join. Just politically, there isn't that much appetite within both of these countries to join in at the moment. Other countries which we can see which aren't there, for example, Ireland, Romania, and Greece, have indicated that they will be joining in the next few years, perhaps even before it comes into effect. And a lot of the so-called Eastern Bloc countries as well, who form part of the European Union, will be joined there. As I mentioned before, one of the big advantages is, of course, you now have this kind of super territorial right, where we're talking of a single market of over 300 million people and 13 trillion GDP. So if you're looking at scaling up damages from a country, for example, France, which is a population of about 60 million, you're kind of looking five times the size, potentially, with incremental sizes in damages as well. And so some of the questions really which we are saying to people, which they need to be aware of in terms of this new system, really is kind of, what are the important markets for you? What can you do? And there's this idea that you might have this hybrid strategy of utilizing a unitary patent and then supplementing it perhaps with national rights, or perhaps even just going to national rights entirely. I'll explain a little bit more of that in a bit later on. So I just wanted to show this visually, what this actually means in terms of the amount of coverage. So on the left-hand side, so in red, those are all the member states which we saw from Devon's earlier slide of the European Patent Office. As I said there are countries which aren't part of the European Union. The countries in blue are the ones which are currently signed up to the countries in blue are the ones which are currently signed up to the UPC, and then the ones in light blue are the ones which are likely to be signed up in the next couple of years, depending on how the courts go. There is, as you can imagine, a bit of kind of perhaps reluctance for people to try these new courts, but these are the potential countries which are likely to sign up in the next few years. So hopefully, as you can see, there's a lot of coverage there. Okay, so as I mentioned beforehand, one of the main effects about the European patent is the idea that that the patent has unitary effect. So you cannot assign your unitary patent into a bundle of national rights as you're currently able to do. So at the moment, if you had, for example, your validations in France, Germany, and the UK, and you had a German subsidiary, you're able to assign your German patent to your German subsidiary. You may assign your French patent to an Irish one, for example, perhaps for tax reasons. That's no longer possible under the unitary patent here. But what you can do is you can still license out country by country. So whilst the kind of the litigation options or the ownership options, let's just say, are slightly reduced, you still have the ability, in terms of at least licensing, to be able to maintain the flexibility which we've normally associated with European patents. Okay, so really, just why are we talking about this? I'm only going to go through this very briefly. As Devon mentioned, really the next step at the moment is what's called this sunrise period, and that's going to happen when Germany officially ratifies the UPC. And the only reason, the unitary patent, sorry, and the only reason it hasn't done so at the moment is essentially it's delaying it until all the ducks are in a row and everybody's ready to say, okay, well, we've only had this 3-month period, this so-called sunrise period. And so they're waiting for all the courts to be fully operational and up and running, and knowing that when they say yes, when they pull the trigger, they've got 3 months and everything's going to be ready to go within that 3-month period. So the best guess scenario, which most people are saying, is going to be hopefully the end of fall, early winter this year. Perhaps there's a possibility of delays, but we are pretty hopeful that this is going to happen sooner rather than later. And as I said before, this has been in the offing for a long time, and I remember doing very similar talks about 6-7 years ago before we voted ourselves out of the European Union. So it's quite an exciting time to be in at the moment. So so really a couple of things to remember then about what the difference is between the unitary patent, or any differences between the unitary patent and the current European patent system. Now, the main thing to remember here is that actually before grant, there is no difference between a European patent as we know and a unitary patent at that stage. It is only an after grant procedure. Something which is going to be quite different for people who are patent portfolio managers is this idea that in order to get the so validations, normally the EPO, you have a 4-month window in order to sort everything out. Now that you have to declare within 1 month of grant whether or not you want your patent to have unitary effect. At the moment, anything which is granted before the unitary patent goes live cannot become a unitary patent. So all your existing granted patents at the moment will remain as they are, a bundle of national rights. They cannot be converted subsequently into a unitary patent at that stage. Once it's happened, then you have this choice to validate or to have this patent in these 17 territories. That's thing to remember as well, which is quite good, is that in terms of costs, there isn't actually that much difference in costs. In terms of prosecution, everything remains the same. There's no extra registration or validation fees. And so it's essentially, there's no difference for patent portfolio holders. You won't notice any difference between a normal, I say, kind of a classical European patent system and the unitary patent system. Where the big change will come in is subsequently after grant, as Devon had mentioned, each country has its own validation fees and the unitary patent is no different. What happens is that there is a single renewal fee which is paid to the EPO. And what we can see in this graph here, if I just talk you through it very briefly, is that in the left-hand corner, sorry, in the kind of the orange color, is the cost of renewals for a unitary patent. The grey bar is the cost of renewals for just the German and French patent. The greenish bar is German, French, Dutch, and Italian. And then the blue bar would be this cost if you validated in all the 17 states of the unitary patent system. As you can see, really there is a break-even point of about 4 territories at the moment. So if you validate historically in more than 4 territories, the going to a unitary patent is cheaper at that stage. However, if you are someone who, as Devon mentioned, would be, for example, mostly France, Germany, and the UK. As the UK is out of it, then you're only in the Germany and France regime. As you can see, the grey bars are substantially lower in terms of renewal costs than the unitary patent bars. So if costs are the only consideration at this stage, then you probably would be needing to think and look at least how many territories you are validating in order to determine whether or not this is going to be a cost-effective option for you. Yeah. So, and now here comes the second part of the package, as I mentioned beforehand, is now we have this new litigation forum which is being introduced, and this is the Unified Patent Court. I'll just go through this briefly. There are going to be local and regional divisions, which are essentially country-based courts, and then there are going to be central divisions as well, which will handle individual technology. So electronics and software will be handled out of Paris, mechanical inventions will be handled out of Munich. As Devon said, life sciences and chemistry were originally meant to be handled out of London, but since the UK has exited the EU, that's no longer the case, and that hasn't been decided where that's going to happen. There are certain aspects as to where, as to which countries and which courts will deal with each litigation case, and we'll talk about that in a little bit. And I think Brianna might have some input as well on that, because there's some potential around forum shopping as well, determining and around rocket dockets as well. So having these different jurisdictions, these different courts, which are allowed to consider different issues, does raise some interesting questions. I'll just talk briefly about this next slide, which is going to be about the competencies of the courts. Now, for those of you who have dealt with German-based litigation, you are probably aware of the system of bifurcation, where validity and infringement and validity are considered in separate courts. Now, this is now going to be a possibility under the UPC, under the Unitary Patent Court. In the cases where a counterclaim for validity is raised at a regional court, then the regional court has the option to send that claim for validity to one of the central divisions. So in that case, you would have different courts considering validity and infringement. So you end up in what, as I said before, this so-called bifurcated system, which is pretty common in Germany. A lot of the patent system in Germany is based on this, but it's something which is pretty new for the rest of Europe. It doesn't occur in the UK and France, for example. And so it's also going to be something for litigators, which they might want to be aware of. I don't know, Brianna, if you have anything, if you had any ideas about bifurcation or how that might affect how you might approach litigation.
Hi, yes. Please excuse me for being late. We had technical difficulties. Yeah, I think one of the major things with Germany and the way they do the bifurcation is it's two separate courts, and therefore there's really no control over which one happens. Like, you might have infringement an infringement opinion come first before invalidity is even analyzed at this point. And then I believe with Germany, you have to then pay, you get an injunction, right? Automatic injunction, which a lot of defendants, since I mostly do defense side, are very concerned with, because it really puts a halt on your products going into Germany, which is a big market, and especially for high-tech science, which I do most of. And so I think it's a very concerning issue to still have bifurcation out and put it across everyone, that everyone would do bifurcation, versus just having to worry about Germany. Now you have to also worry about the other, across, I guess, most of Europe too at this point. And so I think, just watching to see how that really plays out. I don't believe there have been any, they've identified, I guess, the track record, maybe which one might go first, whether it's validity or infringement. I imagine, the alleged infringer would want for invalidity to go first, and then, the patentee would probably want infringement to go first. And so I think they'll have to really work out how to really balance those two interests to make sure that it's fair for all.
Yeah, I mean, one of the really interesting points about the bifurcation in the Unified Patent Court is that the local divisions have the ability to not grant the bifurcation request, essentially. So nobody really knows at the moment how this is going to play out, whether or not some courts feel comfortable, whether they say, yeah, we believe we've got enough competencies on in our judges to determine validity, or whether they just want to palm it off because either their docket's too full or they just they might not be that interested in determining validity. And I can see there might be some, in the first couple of years at least anyway, some kind of strategic considerations as to which forums you bring the validity, you bring your infringement action in, assuming that you're going to get the counterclaim for validity. It may well be a case that you see certain courts being happier to consider themselves not have the bifurcated system, which might be in your favor or might be against. Really does depend on the circumstances.
Mm-hmm.
Yeah, so sorry, yeah, the other thing as well, which I didn't mention, is that there is a Court of Appeal which is going to be held in Luxembourg, which decisions can be referred to the Courts of Appeal, and ultimately decisions can be referred to the European Court of Justice, but I suspect that's going to happen in vanishingly rare circumstances. So yeah, as we mentioned beforehand, one of the more interesting aspects as well is this idea of forum shopping, because now we're in the situation where you have essentially 17 17 countries. Each country can have up to 4 local courts. And determination, and you can also, and anybody can bring, infringement actions into one of the central divisions as well, depending on the area of technology. So again, here, determination of which court you bring your action against is going to be something which might be quite interesting. Again, we don't know enough at the moment as to what the kind of the makeup of the courts is going to be, in terms of, are they going to be particularly patentee friendly or defendant friendly? Nobody really knows, because judges haven't yet been appointed at that stage. But there is this possibility, as we mentioned here, of the so-called rocket dockets. As I'll cover it off in a minute, the main issue with the UPC is that a lot of this is going to be kind of very front-loaded, and so the idea being that it's going to be within 1 year from serving of the initial papers to getting to trial and judgment. So some very, very fast moving courts, which we may see here. And we were talking about this just before we joined on the call, about the potential of utilizing that in your favor, and how that might kind of affect kind of the global strategy which you have in terms of infringement.
Yeah, I just chiming in. I think that 1 year mark, I think that is that in and of itself, I think we consider a rocket docket, because in the US it goes a lot slower. I believe the average was 3 years about now. And you know, in some materials I've seen, they say, I guess for that 1 year, the first 3 months is really, you have to pretty much have your case in chief for the UPC put together. And, you know, we have claim construction for those who, if you're in the patent litigation field. Claim construction is basically you going through the patent and seeing terms and saying, okay, this term means this. So you basically kind of set up a dictionary for what the terms in the patent mean. And that in of itself in the US takes like 3 months already. So this 1 year, I think that'll be very interesting to see how that really plays out. And to me, again, as a defense side, usually that seems more plaintiff friendly, because especially, the plaintiff is the one that's going out there looking for who's infringing on their patent, who can they assert their patent against. And so they'll have all that lead up time up to filing their complaint, to prepare their case, to go ahead and get their experts, to go ahead and get their witnesses that they need. Whereas if, as a defendant, you don't see it coming, then you have to really get up and running in about less than 3 months. From the U.S. side, that seems really outlandish. And sometimes we've helped. If there's been a U.S. case and then later on they file in Europe, particularly Germany, we've helped our client go ahead and push material to use in those matters, in those cases overseas. But we already had like a year or two head start on that too. And so if litigation, it just originally starts, if your global litigation for a patent originally starts in the EU, I'm not sure how really anyone would get up to speed in 3 months to really get it going like that. But I think that's just something you have to work out, and probably just I imagine now they're actually setting up pretty good rules too to get their ducks in a row and to help people go ahead and prepare so that when they are sued, it's like, okay, you have these these set rules. That I think would probably be very helpful.
Yeah, well, absolutely, and as it shows on the screen at the moment, a lot of this process is going to be driven in written submissions to begin with, and there's going to be some very tightly defined rules of procedure. For those of you who've had the pleasure of litigating in the UK, and if you're familiar with the UK rules of procedure, then a lot of the rules were written whilst the UK was still in the EU and were heavily based on the UK system. So for those of you who have got that advantage, have got that familiarity, you might find that to be a bit of an advantage in terms of the kind of the proactive case management by the judges, and having kind of the pre-trial hearings with the judges, and having a lot of these issues sorted out before the trial itself. And the trial is envisaged to be quite a speedy one. 1 day is going to be the typical size of things. Of that, there is a possibility that trials might go on for 2 or 3 days, but really those would be very much the exceptions from what we're hearing at the moment. So it is looking to be a much more streamlined procedure. One thing which I haven't discussed in this is the fees as well for bringing a litigation action in before the UPC it's 11,000 euros and to start an action, and then there's a sliding scale depending on how much cost you want. But for anything less than 1 million, it remains 11,000 euros, and if you go over 1 million, I think it becomes 12. But then the costs increase quite substantially, quite quickly after that. But the point being is that you might end up seeing what we see more and more in Germany, which is because of having this very streamlined procedure, that we might see this UPC court being used to hear smaller infringement matters than we might normally expect. So if you're talking in terms of having a very streamlined procedure which gets you a result within a year, the fees involved there, the professional fees, are going to actually just obviously be much reduced, because there isn't simply enough time in the year to fill that many hours and to get through. But it should mean that costs will be substantially lower as well for the plaintiffs and defendants. And we suspect this has been done to try and encourage a lot more SME style litigation within Europe, which is fairly common in Germany, but not so common for example, in the UK, where litigation costs are kind of an order of magnitude or more than in Germany on that. So it's going to be an interesting time for the litigation side of things. I did wonder, Brianna, and perhaps Devon as well, whether do you think in terms of a global strategy, given the speed and the kind of the streamlined nature of the court, do you think that might affect how you might look at patent litigation on a worldwide basis instead of?
Well, I think in general, probably, the larger clients, like your visas, will probably hold off and wait and see how things go. Just like when we instituted like the IPRs in, back in 2013, and everyone kind of waited to see how it would play out and what would happen. And that was kind of our new breakground of area to go after the validity of patents. And I guess that's why I see going forward to that the bigger players probably hold off. I think, especially with that 1 year, I think the non-practicing entities will probably be the first ones to jump in. And it's just for the timeline itself, because, a lot of them have started to some have kind of gone to, Germany for that aspect before, or even I believe China has a pretty, I believe, fast docket also that they've gone to in order to really kind of encourage settlement at a faster pace versus getting like those things like injunctions that are I think in Germany it's almost automatic that you would get a injunction if there is infringement, although they did, I believe, institute a law in 2019 to try to make it a little bit more, to try to say, oh, well, there are exceptions where we won't issue an injunction, but pretty much I think everyone read it as you're still going to probably get an injunction if there is infringement found. And so I just generally feel more concerned for the defendant, the alleged infringer, that this might be more favorable to them until at least it plays out and we see how it really applies. But just that 1 year mark, that's pretty scary, I guess, for a litigator. And I mean, but we do, and also actually, I misspoke earlier too. We do have, the ITC in the U.S., where International Trade Commission, where those cases happen in a year. I just did one last year, and it's crazy. It has to be done in like I think we should do it in 9 months. And it's crazy next speed for us to do, but it does happen. But it is one of those things where I think it sends tremors through, companies, big, large companies, because you get an injunction for that one also. So that's the only remedy you get. So I feel like it's along that lines of like the ITC in the US. That's why I compare it to, I guess, at this point.
Thank you. Devon, have you got any thoughts on that?
Well, I mean, I think for certain companies, it depends on how you use your portfolio. So for those that are using their portfolio defensively, I don't think it will give them any incentive to change that strategy. But for those that are use it a bit more offensively and then have large licensing programs, this might give them some usefulness in their strategy. But I do agree with Brianna. Probably the trolls and those sorts will be the first to enter the fray once this begins.
No, it's interesting. We've obviously had a couple of NP friendly decisions in the UK and Germany in the last couple of years about saying there's no bar for them, and they're obviously almost encouraging them to to come in at this stage. So that's really interesting. Thank you. So one part as well, which I think is going to be worth touching on here, is as well as having this new forum, there's going to be this situation now where we're this so-called opt-out period, where European patents, as I mentioned beforehand, the ultimate aim for the European Patent Court is that all patents issued by the EPO will ultimately be heard by the UPC. But at the moment, there's this provision which is for 7 years at least, and perhaps extendable to another 7 years, so a maximum 14 years, where patent holders will be able to opt out of the jurisdiction of the Unified Patent Court, and in that case, then you'd be back into the situation where you are litigating your patents back into the national courts. Now, this is obviously only applicable to patents which aren't going to be considered as unitary patents. Patents which are unitary patents will always and only ever be heard in the unitary patent courts at this stage. This is referring to the patents which are the kind of the bundle of national rights, as Devon had shown in his initial slides there. And really, as it says on the slides there, the purpose of having the opt-out period was essentially to allay fears in terms of what does this court look like, how patentee friendly are they going to be, how harsh are they going to be on particular subject matter, and it's almost this idea of allowing the courts to bed in a little, and people who might be, or companies who might be slightly reluctant to try patent litigation within these new jurisdictions have the opportunity essentially to utilize what we call the opt-out at this stage. Now, the couple of things to notice about the opt-out is that the default position for your patent portfolio, so people who are patent holders, this is probably the most important part of this talk, is that if you don't do anything, your patents will be under the jurisdiction of the UPC. You have to actively opt out. So that applies to all existing patents granted by the European Patent Office. So if you had a patent which is 15 years old and it's valid in Germany and France, which are countries which are under the jurisdiction of the UPC, then you will, people will be able to bring invalidity actions against your patents, for example, in the European Patent Court. So you are essentially being provided, or you maybe not provided, you are being forced into the jurisdiction of a new court. And depending on what your kind of commercial objectives are, or your commercial needs, or how you want this to align, that may or may not be a good thing for you. So this, like I said, that this can have this kind of unintended consequence that if you're not proactive with this, you might end up having your patent litigated in a form you don't want it to be litigated in at this stage. So that's really why this opt-out part becomes quite important, because there are lots of considerations around whether or not you may or may not want to form part, you may or may not want your patent to fall within the jurisdiction of the unitary patent court at this stage. So one thing we're also worth mentioning here is that whilst the opt-out lasts for the lifetime of the patent, if you decide to opt out of the jurisdiction of the unitary patent, the UPC, there is the possibility of coming back into the jurisdiction of the UPC. So you may look at this at the moment and say, oh, I don't quite like the look of these courts. This doesn't sound great. This single point of revocation is particularly unpleasant for me. Opt out into the jurisdiction of the national courts, and if after 5 years or whatever the case may be, you look at this and realise that actually you quite like the flavour of this court, it seems to be working in a way which might align to your business needs, there's always the possibility to opt back into the unitary patent courts. The one exception to that rule is you can't, once there has been any form of litigation on one of your patents, on the patent which you've either opted in or opted out, then it remains in that jurisdiction and will do so for the rest of its life. So, for example, if you have opted out and there's been a litigation action based in a national court, you can't subsequently go back into the unitary patent court and vice versa at that stage. So I think Devon, this as a kind of more of a portfolio holder, this type of opt-outs strategies and things might be more interesting to you. In your day to day. I don't know if you've got any questions or thoughts on how this process might work, or what you might do.
I mean, right now, or at least from the talk that I've heard, a lot of the U.S. companies are kind of going the route that you mentioned, and kind of it's more of a wait and see approach. And because we're not sure, you know, in businesses you like known results, and this is an unknown at this time. So until there's a bit more certainty, the opt-out option is probably would actually be the default for many of the technology companies. And then, as you mentioned, once it appears that it's a viable option, then making that choice to opt back into the system.
No, exactly. I think, but the conversations which I've had with European-based companies as well is very much fall along the same lines of, there are some people who feel that actually they want to go ahead and almost see that they've got the possibility to shape the outcomes of the courts over the next couple of years, and seem quite, I think it's more for companies who already have got quite a, who may have been involved a lot more in patent prosecution, in patent litigation, tend to be those who are feeling that, well, actually, the potential rewards are so much higher at this stage that they want to stay within the jurisdiction of the UPC. So what we have here is just really some kind of flowchart just to help kind of structure some thoughts or some considerations which go around in this transitional period. So within at least the next 7 years and potentially the next 14 years, there's always the option of not to use the European Patent Office, and you can file your patent applications directly at national patent offices, be it the UK IPO, the NCPI, the Deutsche Patent Office, whatever you choose it to be at that stage. But obviously in those situations, then you're only ever going to be able to go to the national courts at that stage. If you are using the European Patent Office, the main question is, do you want your patent to have unitary effect? Then if it is, then we go down the flowchart and you have to go to the unitary patent court. And then essentially you have the option to opt out. To do nothing is, as I said beforehand, you end up with the national patents, but they end up being at the potentially at the UPC. So that's then once the transitional period is changed, that becomes slightly easier because you no longer have the ability to opt out of the court. So it'll only be the question of having your national rights enforced within the courts, or having national patents and then those national rights enforced within the courts, or European patents, and then they subsequently will only be heard in the Unified Patent Court. So it is going to be quite a shift change in terms of how patent litigation occurs over time. I imagine those who are more used to having the very technical judges, for example, in the German system, where they tend to have a technical panel, and judges who have a bit more of a technical background might find that to be more convincing or more pleasing to them at that stage. And so some final kind of considerations as well at this stage. Now, if we kind of look at the strategy and why we might look at using the unitary patent, really it is this point about the single market, and the idea of having being able to essentially litigate in multiple countries in one action is the point here. You don't have to repeat the litigation action. There's that consistency. We know the judgment isn't going to change. There is only ever going to be one judgment at that stage. But then on the flip side, as we said, the main real downside is this point of the single point of failure as well, which, in fact, Devon is as a patent holder, is this point about a single point of failure for all of Europe something more of a concern for you guys, or is it something which you're looking at and thinking, well, maybe the pros do outweigh the cons?
Well, most likely it would be concerning. I mean, having the ability to essentially wipe out all of your patent rights in one go is a bit disconcerting to some extent. So I think from that aspect, it depends on the company and the size of the company. So if you're a bigger company, you want your your counterparty to have to spend the money to knock out each individual patent. Whereas if you're a startup, then you don't have the money to validate in all those countries, but you want the coverage, so you might go the unitary patent route to get the coverage and take your chances.
And Brianna, you were saying that you deal mostly with defendants. Is the single point of failure? Do you think that's going to be quite a quite a downside to the system for you?
I think for defendant side, it wouldn't, because it'd be like, great, you just have to do it once to knock it out on defense side. So I think that does look like a pro. I guess in terms of, though, really, again, going back to that 1 year and having to have your case in chief altogether as defense side is a bit difficult. And how is it, I was thinking also too, and just in general, like, if you create the system that's that fast, then you also need to have, I guess, more lenient rules on like discovery, which I know Germany does have. They don't do I think no one does as much discovery as we do in the US, and of depositions and things like that. And so that will also be a lot more limited and reduce costs. And so I think that is a pro for it, even for defendants. It's all around. It seems like it'll be less costly to actually litigate. But it's still at this point, it's a black box, and no one in law likes to deal with the black box and stuff. That's why I stay away from constitutional law. It feels like a black box to me compared to patent law. And so I still feel like that kind of black boxness of it outweighs whatever pros you might have, like single point of failure, too, especially too if there are certain markets that, like Germany, you want to keep that market, and it's likely the one where you'll be sued, or just a bit larger markets. Yes. Whereas if all the 24 countries were equal markets, then okay, maybe might have more impact. But there are just certain markets that are bigger that you want to keep, and so you're okay with putting more money into that one, or to actually actively litigate it.
No, that makes sense. It was something which I didn't mention, the point about discovery and cross-examination. So there is limited discovery in rules of the UPC, and there is the possibility of cross-examination of expert witnesses. But the understanding at the moment is that actually these will be used fairly sparingly. So yeah, the point about not having not spending millions on discovery might be good or bad depending on depending on your point of view on these things.
All right.
I think we're a little over time.
Yeah, I hate to break up another great conversation. I want to thank you all for an excellent conversation and for making the time to join us today. And we have